May it please the court, my lady. I appear on behalf of the applicant. My surname is Baloyi, initial S, and I appear with my juniors, Mr. Tsidiso Ramokhale and Ms. Fatima Mohammed. As the court pleases.
May it please the court, together with my learned friend, Mr. Siv, I appear for the Electoral Commission.
Good morning, as the court pleases. My learned friend, Mr. Sikakane SC, Mr. Shai and Ms. May, and I appear for the third respondents, as the court pleases.
As the court pleases, my lady, our presentation this morning is divided into two. The first presentation is from my colleague, Mr. Ramokhale, and he will deal with the topics of urgency and condonation. We are mindful of the allocation of uninterrupted 10 minutes to make a presentation. We've agreed that we'll split it. He will have 5 minutes of that time, and I'll have 5 minutes of the time. With your leave, if he may.
As the court pleases, my name is Tsidiso Ramokhale. I appear on behalf of the applicant. As my leader has indicated, I'll be dealing with two topics. The first considers the question of jurisdiction of this court, and then the second topic I will deal with is the question of delay. Now, in respect of the question of jurisdiction, we will raise 6 points about why we say that this court, in fact, has jurisdiction to detain this application. And similarly, in respect of delay, we will raise 5 points about why, on the papers presented before you, this is a matter that this court, in fact, should consider. Now, at the heart of the question about delay is whether the decisions of the CEO of the Electoral Commission are, in fact, immune from judicial review, and importantly, whether this court can operate as a court of first instance in respect of those particular decisions. The Commission's answer is that the Deputy CEO's decisions, as well as the CEO's decisions, can never, in fact, be challenged in a court. This position, we say, isn't plainly untenable in terms of the law, and we will demonstrate how on the arguments I'm about to make. But perhaps the starting point is to simply say, as the court is well aware, that there is no power, a public power rather, or performance of a public function that is immune from judicial review. And so the very notion of the arguments made by the Commission in its papers that somehow, despite the Deputy CEO or CEO's decisions being an exercise of public power, performance of a public function, there is no court that can second guess or look into that question. For the reasons, again, like I say, that we will submit, that is simply untenable. We say that the starting point in answering the question of jurisdiction is, in fact, the Constitution. And that power is set out in section 166E, which sets out what the courts are of the Republic. And what section 166E says is that the courts are the Constitutional Court, the Supreme Court of Appeal, the High Court, and any court of appeal that may be established by an act of Parliament, and particularly of importance to this case, any other court established or recognized in terms of an act of Parliament, including any court of similar status either to the High Court or to the Magistrate Court. What this means, and there are authorities that I will take the court through that actually demonstrate that on a proper reading of 166, this is a court referred to in section 166E of the Constitution. This status is set out in 3 legislations that actually govern the ruling of the court. The first is the Electoral Commissions Act, the second is the Electoral Act, and more importantly, the Constitution. And so the first point we make is that this is a court in terms of 166E of the Constitution, and that opens up all sorts of avenues that we will demonstrate about how this court can in fact exercise jurisdiction on the application before it. Which brings us to then the second point, which is what has this court said about its own jurisdiction? We rely on the decision of this court in African Christian Democratic Party, ACDP, the 2004 decision that's cited by the Commission in its papers. And the first point we make about ACDP is that the version that's been put by the Commission in its papers is that this court in ACDP said it does not have the power to look anything beyond the Commission's own decisions, and that it is in fact not a superior court. However, the difficulty with that particular argument is that when the Commission in fact does that, it cites the judgment partially. In fact, when one considers paragraph 12 of that particular judgment, what the court is doing, which is what's cited by the Commission in its papers, is restating the argument by Azapo, not making its own pronouncements. In fact, in paragraph 12, which is the part that's in fact cut off from the Commission's heads, is the court writes, Azapo's standpoint, as I understand it, is that this court is not a court of first instance. It can only deal with matters referred to it on appeal or review. This court therefore has no jurisdiction to deal with a matter which the Commission refused to deal with. If the matter were left open-ended, and that was precisely what Section 25.3 seeks to avoid, an absurd situation could arise. The Electoral Court cannot deal with matters not dealt with by the Commission. The Electoral Court is a creature of statute. It derives its jurisdiction from statute creating it, and unlike the Supreme Court, it has no inherent jurisdiction. That's what the court says is Azapo's argument about this court's jurisdiction. And then here's what the court says towards the end. It says that the review application in the Jamie case, which was the case relied on by Azapo, was brought before a tribunal, not a court. The issue before the appeal tribunal, though in part relevant to this matter, was only related to the leading of oral evidence on a matter not dealt with by the Chief Director. Whilst the judgment is persuasive, it is not binding on this court, and as Mr. Mukotori would have the court accept. Mr. Mukotori did not, it appears, give sufficient considerations to the provisions of Section 20 of the Commissions Act and other related provisions. And the court goes on to quote what Section 20 in fact says. And then it says, in short, the power of this court in electoral matters are wide-ranging. Section 18 of the Commissions Act explicitly accords it the status of the Supreme Court and now the High Court, it says. While there may be merit in the argument that it does not enjoy those inherent powers that the High Court has, it has certainly, in my view, enjoyed extensive powers in relation to electoral matters. It is the final court of appeal or review in all such matters, and it says, see Section 96 of the Electoral Act. Mr. Mukotori rightly and very correctly conceded that his jurisdiction point had no merit and accordingly withdrew it. And then the court says in paragraph 14, part of the problem in this matter is that neither party appears to have considered the effect of Section 20 of the Commissions Act. The applicant pleaded its case based purely on Section 55, claiming relief it would appear under Section 56, contending for a serious irregularity having occurred relating to any aspect of the election. And then in paragraph 15, which is of quite importance, I am unable to agree with the view that the court, in light of the very wide powers it has in electoral matters, cannot, on application, as it is in the case here, correct declared results arising from some underlying administrative error in appropriate circumstances. It would seem to me that by failing to do so, the court would not only be acting irresponsibly, but would be abdicating its constitutional imperative to ensure free and fair elections. It must follow, therefore, that even if there is merit in the second respondent's argument, being Azapo, that the Commission was functus officio in dealing with this objection, this court is nevertheless at large in appropriate circumstances to deal with the matter in terms of its review powers contained in Section 20 of the Commissions Act. So the simple point we make is that the argument that's been advanced by the Commission about why this court does not have jurisdiction was squarely rejected in the very same judgment they in fact rely on. Which then brings me to the second point about, or the third point rather, about how the Constitutional Court has dealt with the jurisdiction of this court. In that respect, we rely on the decision of the Constitutional Court in Calm versus Independent Electoral Commission. In particular, we rely on paragraphs 40 and 41 of that judgment. And there, Justice Wallace, writing for a majority Constitutional Court, writes, is there anything in the context that would warrant a more restrictive interpretation of the section and hence of the Electoral Court's jurisdiction? I think not. The clear purpose was to establish a court that would deal with all matters in relation to electoral matters. It was constituted with the same status as the High Court and with a judge of the Supreme Court of Appeal as its chairperson. It is to resolve electoral disputes as a matter of urgency. there is not the slightest indication that the intention was to limit the range of disputes that would fall within the ambit of the electoral court's jurisdiction, so that some electoral matters would fall within its jurisdiction and others would not. Instead, the breadth of the language used suggests that the statutory purpose was to create a specialist court that would deal with all electoral matters. And our jurisprudence holds that when a specialist court is created, the apparent purpose of creating a single forum for resolving disputes of a particular type is not to be stifled by a resort to undue literalism and too careful a parsing of statutory language. Then in paragraph 41, it says, this construction is strengthened by considering what is empowered by a court of review in this context. In ordinary language, it is a power to reconsider and, if necessary, replace the decision of the IEC. It is not a narrow appeal power bound to a record where the court decides merely whether on the record the decision was right or wrong. Nor is it even a narrow review power where the process through which the decision was taken is scrutinized, but the merits of the decision are not considered. Instead, it is the widest possible type of review where the decision in question is subject to reconsideration, if necessary, on new or additional facts, and the body exercising review power is free to substitute its own decision for the decision under review. And then it says at the end, on the face of it, the jurisdiction of the electoral court to deal with such matters, such as an irregularity, must arise under section 21 of the Commissions Act. It could not effectively exercise that jurisdiction unless a review power under that section is described as above. So then, what then does that mean? And this is then the fourth point that we make about jurisdiction. Here, we say that the finding in calm that this court has the widest possible power in review and is not bound in the ordinary sense as you would consider a review application is consistent with what the court has held in relation to other forums. The one judgment is the judgment of Ledla in the Constitutional Court, where the Constitutional Court said whilst the special tribunal was not a court, it had the power to consider legality reviews given its statutory status and powers. There, the court held that legality reviews fall within the remit of the tribunal's powers as a necessary condition to the fulfillment of its statutory duties. Put differently, how else can the court ensure compliance with the statute that it's specifically been given power to review in the absence of being able to deal with review challenges? And then in Group 5, again, a similar challenge where the Competition Tribunal's jurisdiction was challenged. And the question before the Constitutional Court in that application is, can the High Court exercise concurrent jurisdiction with the Competition Appeal Court in deciding the ultra vires 1 and legality reviews 2? And again, a majority of the Constitutional Court said absolutely yes. And the reason it said so in Group 5, and we find that in paragraph 125 of that judgment, is that when you look at, and we started off with the Constitution, it says that the courts of the Republic are the following, and it sets it out in 166E. And then importantly, in 172(1) of the Constitution, it says a court has the authority and the power to declare any law or conduct that is inconsistent with the Constitution as such. Then the question becomes whether this is a court as defined in section 172 of the Constitution. And we say, for very clear reasons, both in ACDP and in other judgments by this court, that it is in fact a court, and it does have the power under 172(1) of the Constitution to declare any law or conduct that is in fact inconsistent with the Constitution as such. Which leads us to our fifth and penultimate point, which is, this is the argument we've heard a lot from the Commission. Is this a matter that could have in fact been served before the full Commission? In other words, are the ultra vires challenges that we raise here and the legality review we raise grounds upon which the Electoral Commission could have in fact entertained? And we say no. And we say so for three reasons. The first is that the court would have to consider the structure of section 15 and 16 of the Electoral Commissions Act. In particular, section 16(1), which sets out the grounds upon which a aggrieved party can appeal to the full commission. And it sets out three grounds. The first ground is if the 14-day requirement for publication has not in fact passed before the commission renders a decision. The second is if the logo, the name, or the abbreviated name of the party would lead to voter confusion. And the third would be if the name of the party is ostensibly racist or sexist or any of the listed grounds set out in Section 16. The point we make is the only way that the Commission can deal with an appeal is if the grounds which a aggrieved party sets out are in any of those three. The question then becomes, what if a party wants to raise an out of arrears challenge? What if they want to bring a legality challenge? Where do they go? And we say they come here. And we say they come here because this is a court. It is established in Section 166E. It has powers under 172 of the Constitution to declare any law or conduct inconsistent with the Constitution. And as the court knows, that particular power to declare law or conduct stems from Section 1C of the Constitution, which enshrines the rule of law. That's where courts get their legality power. That's where courts can test out of arrears challenges and whether decisions made by a party, in fact, are lawful or not. The second is the difficulty with this argument from the Commission is that it demonstrates an absurdity. And what we mean by that is that it presupposes that the Commission had the power to entertain such a challenge. And as I've argued, the Commission can only deal with challenges on any of the three grounds set out in Section 16. Anything outside of that, it simply has no power to entertain. But the second argument to that is that argument is only good if there was publication the second time around, which is the argument you'll hear about later. And that's because Section 16 demonstrates that the trigger for the right to object and appeal is publication. But in the absence of publication, no party can go to the Commission and lodge an appeal. And as we know from these facts, there was in fact no publication the second time around. So it can't fall in the mouth of the Commission to say you should have objected when there was in fact no publication the second time around in circumstances where it has rejected an application and invites a party to lodge a fresh application. Then there's an argument made in the heads of argument that we raise a new point in reply, which simply has to be rejected. And the point simply is that by relying on the Commission's other powers, the Electoral Act of the Constitution, we make out a new case. But that can't simply hold, because jurisdiction is not a question of fact, jurisdiction is a question of law. And what the court does is it looks at the pleadings as pleaded, and it asks itself, on the pleaded facts, do I have jurisdiction? If we were to take the argument of the Commission to its logical conclusion, it means that where a party has not stated that the court has 172 powers, the court is simply deprived of exercising those powers. That simply cannot be, because the affidavits don't establish the law, they establish the facts. Then the last point we make about jurisdiction is Section 1691A2 of the Constitution. And what we say about this provision is that 169(1)(2) of the Constitution asks the jurisdiction of the High Court. Put differently, that the High Court doesn't have the power to entertain the kind of matter that's before the court today. This is because Section 169(1)(2) makes plain that the High Court does not have jurisdiction over constitutional matters that fall within the statutorily prescribed powers of a specialized court. In other words, you cannot go to the High Court and complain about an out of arrears challenge or legality challenge in electoral matters because this court in fact exists. That's what 169(1)(2)A actually says. And as the court knows, challenges to out of arrears, challenges to legality are in fact constitutional matters, and there's ample authority in support of that particular proposition. So what we say on the last point is that taking 169(2)(1)A into account, it would appear that review applications that are within the realm of electoral laws fall within the jurisdictional bounds of specialized courts, such as this particular court. I then move on to my last submission dealing with delay, and I'll speak briefly about those submissions. I'm mindful of the time. The first question is, are we actually late? And we say that we are not. But to the extent that we are in fact are late, we ask for condonation and we say there's a strong case made out in the papers why condonation should be granted. The starting point in that argument is that in the Constitutional Court in Buffalo City Municipality versus Asla Construction, at paragraph 49, the Constitutional Court says the proverbial clock starts running from the date that the applicant became aware or reasonably ought to have become aware of the decision in fact taken. And we say that on the facts, at worst for the ANC, the 24th of November, when its appeal was refused by the Electoral Commission, is the date on which you must start that clock. And at best for the ANC, that clock starts on the 7th of January when it learns the reasons for the rejection. And that's where the alter vires and the legality challenges became apparent. But even if you were to calculate either from the 24th of November or from the 7th, we say on the 7th of January, we were here in court on the 10th of January, that falls within the 3-day requirement. But if the court says at worst the 24th of November, that's still 29 court days. We've seen in the Electoral Commission's papers that they use calendar days, obviously to demonstrate an exaggerated amount of delay. But 29 court days is how late the ANC in fact was. And the question becomes, and this is the second point we make about delay, whether those 29 court days, if we are in fact incorrect on the 7th of January as the start of the clock, the question becomes whether that 29 court days is unreasonable. That's the starting point. And this court very recently in January of this year, in Electoral Commission versus Umhlatuze, said that the starting point with legality reviews is not the same as 180 days in Paja. The test is whether did you come to court within a reasonable amount of time. Now we know of the 3-day requirement in Rule 6.1 of the court's rules. But the difficulty with the arguments made by the respondent is that it stops short of simply saying you were late by 3 days and no more, therefore that's unreasonable. That can't be the measure. Because as Mhlatuze says, the measure is you look at firstly whether the delay is in fact unreasonable. And how you in fact do that is the court says, firstly, this court says in Mhlatuze paragraphs 11 and 12, that where the delay can be explained and justified, then it is in fact reasonable and the merits of the review can be considered. But where there is no explanation, this invariably means that in fact the delay is in fact unreasonable. But what this court says about the first test of that, because it's a two-pronged test, is that it involves a factual analysis that requires the court to make a value judgment, having regard to all the circumstances in the case. In other words, what the court says is where the interests of justice require overlooking the delay, then the court must in fact do so. So what we say about this is, number one, we say we weren't late if you start counting from the 7th of January. But if we were, 29 court days is not unreasonable in the circumstances of this particular case. The ANC sets out what the reasons are for its delay and the fact that this application was lodged in December of last year. And if the court then finds, if the court thinks that the delay was in fact reasonable, that's the end of the inquiry. However, if the court is of the view that the delay was unreasonable, then there's a second test, or the leg of that inquiry. And that requires, as this court says, a flexible analysis that looks into a legal evaluation, taking into account a number of factors, such as potential prejudice to the affected parties, as well as the possible consequences of setting aside that decision. And we say again on the facts that it simply cannot be that when a party is late by 29 days, court days at worst, that can in fact be said to be unreasonable. Then the third point we make about delay is this. Does delay in fact mean that this court should dismiss the application? And we say no. And we find authority for that again in Buffalo City Metropolitan versus Asla Construction. There at paragraph 63, the Constitutional Court says in a majority judgment that even where there is no basis to overlook an unreasonable delay, the court may nevertheless be compelled constitutionally to declare the state's conduct unlawful. This is because section 1721A of the Constitution enjoins the court to declare invalid any law or conduct that finds itself to be inconsistent with the Constitution. So what we say about this particular judgment is that even if the court were to say the ANC was unreasonably delayed in its 29 court days, the buck does not end there, because 172 of the Constitution compels this court to declare any law or conduct to be inconsistent to the extent of that inconstitutionality. And then it adds a paragraph 66, relying on the well-known Gijima judgment of the Constitutional Court about delay, that the court says, Gijima dictates that where the unlawfulness of the impugned conduct is clear and not disputed, then this court must declare it to be unlawful. This is notwithstanding an unreasonable delay in bringing the application for review, for which there is no basis for overlooking the delay. Whether an impugned decision is so clearly and indisputably unlawful will depend on the circumstances of each case, and you'll hear more from my leader about what we say about that. So we say if we make out a case of illegality, which we say we have, the court has no other choice but to declare that conduct to be unconstitutional, despite the delay. And then finally, on the point about delay in Khumalo at paragraph 25, Khumalo versus MEC, the Constitutional Court cautioned against allowing a procedural objection from preventing the court from looking into the challenges of lawfulness in the exercise of public power. There, Justice Guaiya, for the majority of the court, says, in the previous section, it was explained that the rule of law is a founding value of the Constitution and that state functionaries are enjoined to uphold and to protect it by, inter alia, seeking the redress of a department's unlawful decisions. Because of these fundamental commitments, a court should be slow to allow procedural objectives to prevent it from looking into the challenges of lawfulness of the exercise of public power. And we say that's what the court is here to do today, to look into the lawfulness of the exercise of public power by the Deputy CEO of the Commission. And then finally, on this point about delay, the court must ask itself, what are the consequences if it were to turn the ANC away? We say that there are three. The first is, in Calm and several other judgments of the Constitutional Court, and in fact of this court, lawfulness of decision-making is placed at the center of a free and fair election. And we say that if you cast aside the rule of law in this particular application, there is a very serious and material threat to whether the elections that we're about to have on the 29th of May are in fact free or fair. This is because there are questions regarding the legality of a party on that particular ballot and whether that party should in fact be there in the first place. And so we say that's not an issue that the court should turn away from. It's the very thing that this court was established to decide, to protect free and fair elections, to protect the right to franchise, but importantly to uphold the rule of law. The second point we make is that the closer you get to the elections, the greater the prejudice, not only in fact to MK, but again to the very project of free and fair elections. We say because if you are to in fact do that, as the court is aware, the calculation of seats in the National Assembly is dependent on the votes of each party in relation to one another. So if we are booted out and we're told this court doesn't have jurisdiction or the delay is in fact excessive, what that invariably means for us is that we will have to go to the High Court, despite the fact that we say on 169 of the Constitution, the High Court doesn't in fact have jurisdiction. And if the High Court were to rule in our favor, the invariable position on 172 is, one, it will have to declare that law or conduct to be unconstitutional, and two, it will have to attempt to unscramble the egg after the 29th of May. And we say that is an undesirable position because invariably if the calculation of seats in Parliament are dependent on how each party performs in relation to one another, if you take out MK from that particular equation, the entire equation would have to actually start afresh. And we say that's an untold consequence the court should in fact try to avoid. And lastly, and perhaps the most importantly of all of these, is the Commission tells you in their answering affidavit, and you'll find that at page 87, paragraph 47.2, that this is how they always do things, that they consider supplemental application, whether they meet the requirements or not. And we say that there is absolutely every need for this court to decide on the merits whether the way in which the Commission has exercised its power is the way it should always exercise its power or not, where it considers supplemented application. There is a need to provide the Commission guidance on that aspect, particularly because I think they touch 3 or 4 examples where they've done it with other parties. So if we are correct that the way in which they've been exercising that particular power is unlawful, there's a need to stop that now. Because it's not just about this election, it is about every by-election, every local government election, every municipal election, every provincial election, every national election thereafter, if the way in which the Commission has been exercising its power, which we say is unlawful, continues. So there is every need, we say, on the papers before you to consider the application. We say that the court amply on 5 points that we make has jurisdiction. We say on delay that it's one, we're not late, but to the extent that we are, it is not unreasonable on an assessment of this court's authority. But in any event, even if we are in fact late, it doesn't mean that the application is dismissed. You must still declare the law of conduct unconstitutional because 172 enjoins the court to do so. Milady, those are all my submissions.
Mr. Ramukhali, your client is contending for both urgency and condemnation, and you seem to have argued the 2 points in one stroke when the tests for each is different. So I just want to clarify if you're still persisting with the urgency argument, because you focused on the condemnation leg.
I'll make 2 points about urgency, and I'm mindful of time. The first is that the statute expressly says matters of electoral matters are inherently urgent. And we said the statute already gives an indication to the court how we must in fact deal with this matter. The second is similar, related to the arguments we make about delay, that we came as quickly as we possibly can, and that our delay in fact is not unreasonable if the court finds that there is in fact a delay. But the third point is that this is so important given that the 29th of May is around the corner, that if the court turns a blind eye to that, there is simply no substantial redress available to the ANC because of the unscrambling egg argument I in fact made, that you simply can't turn us away now because the 29th of May is around the corner and there's every need for legal certainty about whether MK is going to be on the ballot lawfully or not. And that's not something that can be kicked past the 29th of May. It has to be decided now. Thank you, judges. Those are my submissions.
Just before you sit, I want to take you back to the issue you argued on the question of whether or not in the replying affidavit there was a new case that you made. Are you saying in your appeal the same ground that you are raising now, that there was no application before the DCE, the DCO or the CEO? Are you saying that that argument was raised when you raised your appeal?
No, Judge Shongwe, as I understand the point on the new case made out in reply, it is that we are now seeking reliance on the Electoral Act, when in our papers, in our founding affidavit, we didn't specifically mention the Electoral Act. We say that can't be a new case. It's common cause across all parties that the ANC did not, in its appeal to the Commission, raise the alter vires challenge, raise the legality issues. These are issues being decided for the first time by this court. The argument in the heads of argument is, by relying on the powers of the court in the Electoral Act, we make out a new case on jurisdiction. And we say that's not, in fact, the case.
Thank you, Councillor. On the issue of jurisdiction.
Yes, Professor.
You know, the powers of this court are expressly stated out on what it should, which decisions rather it should review, being those of the Commission. But you seem to be relying on a quote of several cases that it can obviously exercise implied powers. But in those cases, I've quickly looked at them. I don't see any that supports your argument. Do you have a specific one that authorizes this court to go beyond the statutory jurisdiction?
In the, thank you, Professor Polk. In the ACDP decision, the 2004 one, the issue in there is that there was no commission decision at issue. And the question the court was faced is whether it can correct the administrative error, as it called it, despite the Commission, in fact, not making that particular decision. And the answer it gave is that we can, because we are a high court, and as an incidental power of the review power, it extends to legality and alter vires challenges. So we say on ACDP, on a proper reading of it, particularly paragraph 15 of that judgment, that's in fact clear. But the second point is, even if you're not with us on whether it's a commission decision that is a subject of review, the papers make out an application for declaratory relief, and that's where the arguments about 166E of the Constitution, 1721A of the Constitution fall in. Because even if the court might not have powers on the review of the commission decision, it certainly has powers under 172 of the Constitution to declare any law of conduct inconsistent. And that extends to decisions by the CEO, because those are exercises of public powers in the performance of a public function. So you don't escape either way, is the point that we make.
Thank you.
Thank you. I'm indebted to the court.
As the court pleases. My lady, my task is to deal with the merits of our application that is serving before you. And perhaps it is important to start off with making it clear, to the extent that there may be some uncertainty, especially between us and the second respondent, that the dispute that is before the court, it's a dispute between the applicant and the IEC/deputy CEO. That's what this dispute is about. We don't seek any relief against the second respondent. And the second respondent is cited because of the interest that it has in the matter. But they are not the target. We're not criticizing them for what they have done. We are criticizing the DCEO, the Deputy Chief Electoral Officer. That's where our criticism lies. And the criticism is he did not exercise his powers lawfully. That is the criticism. Indeed, the consequence, if we are successful, is if we are upheld on our complaints and on our submissions to you, if we are upheld, the consequence is adverse to the second respondent. But that's all it is. They become collateral damage. The third respondent, I do apologize. Yes, indeed, the third respondent. So the third respondent, we're not fighting with the third respondent. We are questioning the exercise of statutory authority by the first and second respondents.
Also, Mr. Loy, before us, the issue relating to the name and the mark of MK, that is not an issue before us.
I was getting to that. It is one of the things that I want to clear out of the way.
Because
so,
that was the decision that was taken initially,
yes.
And related to the publication of the name, etc., and the mark.
Yes.
And there was no objection to that. Yes. That name and that mark was then incorporated into the registration as a political party.
Yes.
But that dispute, because I understood the appeal to the Commission to have been on the basis that the mark is confusingly related to us as the ANC, yes. And therefore we object to the registration of the ex post facto.
Yes, yes.
But that is not before us. We don't have to deal with that.
That is not before you. And to the extent that we've referred to that appeal or the facts of that appeal, it is by background information, because we set out a matrix of what happened and we give you a timeline. It is not the dispute that is before you. It is completely irrelevant.
Is whether or not the procedure that was followed, whether that is unlawful and unconstitutional.
Indeed so.
And whether that translates into
indeed so, Judge Adams.
Ultra vires legality issue.
Indeed so.
Yes.
And in fact, that acceptance or that recognition that appeal is not before you, the fight about that appeal is not before you, dispenses with the third respondent's contentions about preemption, for example. We should not even have to canvass that, because we are not here seeking a review of the Commission's decision on appeal. Never mind that the facts are not pleaded for preemption. There are those problems with it, but it's not an issue that you have to decide. It doesn't enter this equation. Similarly, the first and second respondents raising eau de Kral. They raise it, they're entitled to raise it only if we were here about the dismissal of that appeal, about the decision of the Commission to appeal that decision. Then they would say, in fact, we even have a ready answer for that. They would raise it and we would say, but that's exactly why we are here. If we were here about that appeal, we would say, that's exactly why we are in this court. It's because eau de Kral says that decision stands until it is set aside by court. But it doesn't enter the picture because we are not here about that appeal. And all that is said in the papers about the appeal and the decision of the Commission is irrelevant for purposes of consideration, of determination of why we are here before you, of our application. Now, the facts, in fact, perhaps let me start with what our case is. We say to you we say that the application before you is about two things that we have pleaded. It is the exercise of the power to approve the registration of the third respondent after the Deputy Chief Executive Officer had made the decision to reject that application. That's the first issue. The second issue that we have pleaded as a complaint for determination is about a defective Section 15.4a notice, where we say it doesn't comply. We don't persist with that leg of the argument, so you will not hear any submissions from us on that. Now, and we set out in our case, we set it out in the founding affidavit at paragraphs, and I'll just mention them for noting because of the constraints of time. We set out at paragraph 11 and 12 of the founding affidavit what it is that brings us here. And then in paragraphs 19, 22, 68, 70, 71, 72, 75, 76, and 77, we set out the facts, the complaints that we are raising, and why we say the decision that the registration is liable to be set aside. It is in those paragraphs. And at paragraph 20, we say there was no new application before the Deputy Chief Executive Officer to decide. And then at paragraph 20, we say insofar as he gave the opportunity to supplement that application that has been rejected, he acted ultra vires powers. Now, the facts, the relevant facts are largely common cause. And it is this. It is on the 4th of August, the application for registration is rejected. And it is rejected, and there's an invitation, an unnecessary invitation, but a helpful invitation, because the IC has to be helpful to applicants for registration. That says nothing precludes you putting in a new application. We say that was unnecessary to say, but in the discharge of a public function to be of assistance to members of the public, they state that. And that's all that it is. That in itself, that kind of invitation or assistance, we don't complain about it, that they told them what to do. Now, it is also common cause that there was no new application on the IEC's case and on the third respondent's case. No new application was submitted. I must say, Milady, that in fact, in the answering affidavit, the third respondent initially prevaricates about it. They are firmer in the heads of argument. But in the answering affidavit, they speak of it as whether it's a new application or a supplemented application. They quite noticeably do not commit to what it is that was before, certainly not in the answering affidavit. But they do in the heads of argument. They say, well, we supplemented. So we know there was no new application. We know from the IEC that it considered a supplemented application, not a new application. And the supplementation, which is the word that they use, the supplementation is the replacement of signatures that according to the letter of 4 August appear to be fraudulent signatures, and the supplementation that we are told about is they put in a new list of signatures. So that is the supplementing. We say, so before you, what you're required to decide then is whether that So what we do know, perhaps let me finish off the matrix of common cause facts, is that then on the 7th of September, the DCO makes a new decision. And that new decision is now to register, and it is made on the basis of a supplemented application. So the question before you is, the first question would be, was the decision of the DCO to reopen that file, and will make submissions to you that once he's rejected the application, that application is defunct. That file is done and it's closed. And we will show that on the Commission's own papers, they understand the difference between a live application and an application that has been rejected. They understand that. So what they do is, so the first question is the decision of the DCO to consider a rejected application, allow it to be supplemented, and then make a decision on the basis of that application. We say it's not permissible because the decision to reject that application was a final decision. And it is a final decision, but by its nature, however one constructs and interprets the letter of 4 August, it is clear by dictionary meaning, it is clear by context, it is clear by the reasons given for rejection of that application, that it is a final decision to reject an application. But if there was any doubt, it is clear in the advice that is contained in that letter that put in a new application, that the DCO considered himself to have dealt finally with that application.
Ms. Baloyi, I'm troubled by the way your client responds to the Commission's version about its intention when it sent the 4th August letter. And perhaps you should look at these paragraphs so that you can assist me. I'm saying I'm troubled by the manner in which your client responds to the Commission's version regarding its intention when it sent the 4th August letter. And I think it would assist if you go to these paragraphs so that you can assist me. Either your client is approbating and reprobating, or there's an ambiguity in its reply. If you look at paragraph 5 of the 45, of the Commission's answering affidavit.
The Commission's affidavit?
Answering affidavit, yeah. It says in sending a 4th August letter.
I do apologize.
Paragraph 45. Let me wait for you to get there.
Yes.
Are you there?
Yes, I am.
Yeah, it says in sending the 4th August letter, the DCEO did not intend to foreclose the possibility of Umkhonto Wesizwe submitting a supplemented application, right? And your response appears on page 210 of the bundle. It's paragraph 65 of the reply. And there's an admission there that the door was not closed on the MK part to supplement. You see, the allegation you are responding to is that the door was not closed to supplement. And then there's an admission that indeed there's an admission that the door was not closed to supplement. Yes. But then you go on and your client says, however, I deny that the Commission invited them to submit a supplement.
My lady, what is contained there, it's two things. Your ladyship would note that in our founding affidavit, we do make the point that once the application was rejected, the door was not closed for them to to bring in a new application. We say, and as a matter of law, they could have submitted a new application. Yes. And that's what the letter of 4 August was conveying to them, bringing a new application. So where we say that we admit that the door was not closed to them, it is simply to that.
But the paragraph under that you are responding to,
yes,
it relates to the intention not to preclude them from submitting a supplemented, not a fresh application, yes, a supplemented application. And your client's reply there is an admission that the door was not closed.
Yes. My lady, it depends. One cannot read the replying affidavit divorced from the founding affidavit. In the founding affidavit, our position is unequivocal. And that's where we make the case. That's where we make the case, not in the replying affidavit. We make the case in the founding affidavit and unequivocally say that the door was not closed to them. They could bring in a new application. We say no more than that. Now, here when perhaps it's inelegant drafting, but this paragraph that your ladyship is referring to in the replying affidavit has to be considered with what we say in the founding affidavit. And in the founding affidavit, where we make our case, we say they could have brought in an application. But further on, in that same paragraph 65 that your ladyship is referring to, if we are in any way not clear, because we drafted in the way we did that first sentence, it is clear as we continue that we are disputing an invitation to supplement. So that's what the next sentence communicates. It says, well, there was not even an invitation to supplement. Yes, if the commission had said supplement in its letter, what your ladyship I would expect, what your ladyship would see in that paragraph 65 would be a clear statement of he was not authorized to invite them to supplement. But that's not anything new that arises from the replying affidavit. If you look at our founding affidavit, we do quite clearly say that that they could not supplement. The door was not closed to them to put their name on the ballot by putting in a new application, but they could not supplement. And your ladyship has submitted affidavit, founding affidavit must be read together with this replying affidavit, and that should clear any uncertainty in what we intended to convey in the replying affidavit.
Perhaps before you move on, I've got another question for you. I should raise it now. There's a point your client takes about the lack of a distinguishing mark in the third respondent's application.
The lack of?
A distinguishing mark.
Yes.
In the third respondent's application that was submitted to the commission. The application appears at page 111 and 112 of the bundle. It appears to be a copy. So I just want to clarify, perhaps this question I should leave to the commission and the third respondent. Perhaps I should clarify if you are persisting with that point. Are you persisting?
About the absence of a distinguishing mark?
Yeah, in the application.
No.
You are not persisting with that point?
No, my lady, it falls under the complaint about the notice that the Section 45 notice was non-compliant. We have abandoned that complaint. My lady, so I was at a point where I was saying we look, what the court would have to consider is the decision that was made to register, and then to the nature of the decision of the 4th of August, because the respondents say that's an invitation to supplement. It's not a final decision. So the court has to consider that letter. We have the tools of interpretation apart from the terms of the letter itself. And our submission is the letter unequivocally communicates a rejection and an invitation to reopen the application, to put in a new application. But in fact, I said earlier, my lady, I made the submission that the commission and the CEO, they know the difference. And in their answering affidavits, they know the difference between keeping an application open to allow it to be supplemented and making a decision that rejects an application. The differences, that there is a difference. Before you reject, at least that's what they have done in the past. Before they reject, they have given a party the opportunity to supplement. And in fact, what they did in that case, my lady, I just need to find the reference. This is a decision. Yes, this is a decision in an email. If your Lordship would go to page if the court would go to page 121 of the bundle, this is the Commission's answering affidavit. And this is from Mushwana Akani, and it is to yes, it is to Mr. Jabulani Khumalo. And this is sent on the 22nd of June, 2023. It says, your application for registration of a political party refers. Please note that the registration is done in accordance with Section 15 of the Electoral Act and as prescribed. Kindly note that in order to meet the requirements, your party must comply, and it is listed, submit a deed of foundation, and then Annexure 2 must reflect only one logo of the party. And the next paragraph is important. It says, we request that you respond by no later than 14 days of this correspondence by sending additional list of supporters required. Please note that your application will not be processed until we have received all outstanding documentation from yourselves. Failure to comply will compel us to reject your application for registration. So what the Commission does here, or what Mr. Akani does, is to say to them, your application is still live. We haven't finalized it. It's still live. There are problems with it. Fix those problems. And he prescribes a period. Sensibly, one would say, well, if there is a power to supplement, it could never be a power that is open-ended, or in fact that allows a party to take its time and submit and leave this application hanging in the hands of the IEC. There has to be prescripts. You have to do it within a period. And that's what they do in this letter. They say you have 14 days to comply. If you do not comply within 14 days, we will reject your application. This is what they do on the 22nd of June. The letter of the 4th of August is completely different. It says your application has been rejected. And what that points to is the Commission is alert to what is possible to do before you reject an application, and that which they do here is to keep the application live. And they say so in so many words. They say, we will hold it, we will not process it until you have submitted, and if you don't submit, we will reject the application. So the new explanation that, well, this letter of rejection, forget what dictionary meaning of rejection is, forget the context of the letter, in fact, including this history, because this is to the same party. So the history is relevant, the history of how they have dealt with this previously, this same application. They've told them, if you don't do this, we will reject your application. And they proceeded to do that.
Is that similar to giving them an opportunity to supplement?
In this letter, indeed so. We say, in this letter they say, we don't have I must say, Judge Chongo, we don't have the full history of this and what is behind it and what was submitted.
Yes, but the content of what you are reading now, they're giving them an opportunity to supplement.
Indeed so.
So the CEO or DCO has some kind of discretion.
Well, Judge Chongo, you would have seen that we say there is no such discretion, but that suggests that him writing in this way suggests that he considers himself to have a discretion to do this. Well, we make the firm submission that any exercise of discretion has to be grounded in the Act itself.
But the Act does not, in any case, say that an application cannot be supplemented.
The Act doesn't say that, but the Act is silent, but he is a creature of statute. And what the Act has done is to define his powers. And the power, any discretion that he has to be found in an interpretation of the enabling provisions that, in fact, it's a reasonable interpretation that it includes that he has a discretion to allow supplementing applications. But what we say is, well, even if he does, even if we are wrong in our assertion, that because the Act doesn't prescribe that he's got a discretion to permit supplementing of applications, even if we are wrong with that, the decision of 4 August remains an unlawful decision, because that's not an invitation to supplement. He's made a final decision. He is functus officio with that decision. But effectively what he has done with the reconsideration of the same application is he has gone and revised his earlier decision, because that is the legal consequence of what he's done, especially because he bases his decision on the very application that was rejected. So what he's done is, I think an example would be, maybe practically what would happen is when an application is rejected in the public sector, is it would be marked rejected. That's one picture that one has in mind. It would be marked rejected and it would be filed away. Even if it's not marked rejected, it would be filed away because it's done, it's finished. There's nothing more to do with that application. Now, to get to a point where he reconsidered that application on the basis that it is supplemented, he has to retrieve that rejected application. He has to retrieve it and then reconsider. So effectively, he sits in a position where he reviews his own decision and reverses it, because that's effectively what he has done. So we say he's not authorized by the Act to do that. That decision was done, that application became defunct. There was no application before him for further consideration. An application would come before him if a new application was filed, as he advised the third respondent to do.
4 August, could you please take me through the last paragraph, first and second respondents answering affidavit?
Professor, you say I should look at the last paragraph.
The last paragraph.
Yes. It's page 44. I do apologize, Justin. It's page 44. Yes, the last paragraph.
Annexure AA7.
Mine is FA4. Yes. Yes, we attached it as FA4. Yes, that's what I was looking at page 44. Yes, the last paragraph.
Yes.
Professor says the application, therefore, does not substantially comply with the provisions of Section 16 of the Electoral Commission Act and regulations. And then there's a signature. This rejection of the application does not debar you from submitting a fresh application.
Yes, I want you to pause there. What does that afresh mean? Doesn't mean you can supplement what you have already submitted, but address the shortfalls that have been identified?
Yes.
Or does it entail completely coming up with a fresh application?
Professor, not to be facetious, I must say that I'm actually even embarrassed to pull it from my file. The dictionary meaning of, Oxford Dictionary meaning of fresh is new. That's what it is.
Totally different from supplement.
Yes. So you cannot supplement. You can't be supplementing if it is a new application, because what the third respondent, assuming that the third respondent considered, and it must have, because this letter speaks for itself, that the third respondent considered itself to be submitting a new application when they supplement. The debate would be, well, let's look at it. What did you do with it? Right? What did you do? But we know that the letter says, just complete the signatures. Give us that signatures. So there is no new application by any definition. In fact, The third respondent doesn't assert that it submitted a new application. It doesn't. It makes common cause with the IEC that it's supplemented. And we say, but the decision maker said to you putting a new application. Now, what this decision maker then goes on to do is to revise that decision that they made, which is, I want a new application from you. And later on when there's now supplementation, they tell us in their papers, makes the decision, well, that decision that I made is now set aside, because that's really what he did. It's now set aside. I will now consider this old application as supplemented.
Yeah.
And there's no other way of coloring it.
Let us roll the wheels back just a bit. The 1st of June 2023, when an application was made and there was an opportunity to make objections. 9 June again, opportunity to make objections, and nothing occurred. What would have had happened there had the objections been made?
At which point, Professor?
Between 1 June, the first period being the 1st of June 2023, on the first application, wherein the commission, the Deputy Chief Electoral Officer identified some concerns regarding the logos.
Yes.
And your client there had never made any objections.
Yes.
The second period, that is the 9th of June, again, no objection whatsoever forthcoming up until you come back now to the rejection afresh.
Yes. Well, Professor, what we say is that we did not object in the first and second notices is of no consequence to the application that is before you. It is of no consequence whatsoever. It would be of consequence if there had been a new application, as this letter says, of August, if there had been a new application and we did not object. If a new proper application as required by Section 15, which means they would have had to publish the notice, they would have had to submit a new set of documents. By new set of documents, I include that they may well have wanted to run copies of the same old set of documents that are now complete and submit this to the commission. That would be a new application. We would be entitled, if we have good grounds, we would be entitled then to object in that 14 days period. If we did not object, this is a new application, if we did not object, that question would arise. The question would arise for debate, that why are we here if we did not object? We may well have an answer. We may well have had an answer, and the answer would probably have been that, well, that in fact, I think it's in fact, let me take a step back, Professor. I think what we have before you today is a complaint about which we could not object. It was incapable of an objection, if for no other reason, for the reason that it was not published, this application. So we are not hit by the inability to object, because you can only object when you have notice, when you know this is the application, have you identified grounds for objection. So we could not have objected to this application. So the history of not objecting is irrelevant with respect. It's irrelevant because that has nothing to do with the application that is presently, or the complaints that we are raising before you, but it is also irrelevant because the grounds on which we rely, we seek a review of a decision. But that decision is a decision that is made after the expiry of the objection period anyway, by its nature, because the period runs 14 days for objection. The commissioner, the electoral officer doesn't receive an objection. He assesses the application, as in this case, assesses the application and decides it does comply, right? It does comply, and let me register them. Our complaint arises only at that point, how he came to make this decision.
Ms. Baroi, I don't intend to cut you, but I'm very concerned about time.
About time.
You've gone 25 minutes over the allocated time, and we will have to afford the other parties the same benefit, and we will run into difficulties with time because this matter is set down for one day. So I'd like to urge you to conclude your argument by 11:15, and you will come back to reply, so you'll have an opportunity to raise any pressing issues that you needed to raise with us.
Well, my lady, in fact, I think what we're doing, the further submissions that I would make, we fully canvass them in our heads of argument. And the submissions that I'm making are really just to emphasize. We're not bringing any new facts before you or any new argument before you that is not already within our heads of argument. So I'm happy to stand by our heads of argument. But if I could just address the supplementation issue, I'd already touched on it. That our criticism, firstly, you would have to find to get to the supplementation question. You would have to find that the letter of the 4th of August is an invitation to supplement. You would have to find that, right? So our complaint that he was a functus officio and that it was a final decision doesn't stand if you find that, if you interpret the letter in the way that they want you to do. And then once you've made that decision, then the next question naturally is what we raise, which is, well, does he in fact have the power to do that, to call on them to supplement? If the answer is yes, he does have the power, and which we say he doesn't have the power, the next question would be, well, is what was done supplementing an application, right? So you first have to say that decision is not final. That application was still live, and therefore it is capable of supplementing. The corollary question is, does he have the power to supplement, and where does he draw it from? And we say he doesn't have the discretion to do that. In fact, we raise the concern that any suggestion that he's got a discretion, you would have to say, does he have an unfettered discretion? What are the boundaries of this discretion? Because the Act doesn't tell us anything. When can it be exercised? Does he have that discretion? What is the breadth of that discretion? And is that consistent with the provisions that strictly regulate him, what he's permitted and not permitted to do? We raise a concern that if it is suggested that he's got an unfettered discretion, then we enter the realm of arbitrary, unregulated decisions that only the electoral officer knows when and why he exercises it. It cannot be. That is an untenable proposition. Finally, my lady, I need to make the point that the explanation of this letter, it doesn't fall in the mouth of the third respondent to offer any explanation about the interpretation of this letter, because it requires getting into the mind of the author of the letter. We know Godin versus EFF tells us that it is the decision maker that must explain their decision, that provides reasons for their decision. So the third respondent, it doesn't lie in their mouth to explain what this letter means. It's irrelevant that they understood it to mean contrary to what it says on its terms. And we submit that, in fact, it is convenient and opportunistic for them to say, we understood it to mean what the Commission is saying in its affidavit. It is for the Commission to explain the decision. But in fact, in this case, the decision, in fact, the decision to reject, but not to reject, to afford the opportunity to supplement and put it in this way, and what was intended with it, in this case, we say it has consequences, that the person that is providing this explanation is not the author of the letter, is not the decision maker. We have Mr. Mamabulo who didn't make the decision. So before you, the court doesn't have an explanation from the decision maker and the author of the letter to speak to this explanation or this interpretation and what is supposed to have gone into the thinking of why I'm giving them the right to supplement, and I'm doing it in this way. My lady, those are my submissions. My learned junior points out, and I will not say much other than to reference it, in the Africa Rise matter at paragraph 15.
Please deal with it in reply. Please deal with it in reply.
Yes. So what it is...
Baloyi, I'm trying to stop you at this point. Please deal with it in reply.
I'm sorry, my lady.
Yes,
I didn't understand. Yes. Well, finally, my lady, we submit that we have made a case for the relief that we seek, which is that the decision, for the reasons that we have stated in our written heads and in these submissions, the decision stands to be reviewed and set aside. That's one. Alternative relief of a declarator, that you must find that the ADCEO acted ultra vires his powers when he gave the authority to supplement. As the court pleases.
Thank you. We are going to take the tea adjournment at this point, Mr. Motau, for 15 minutes, and then we will hear you when we come back from tea. Thank you.